Our next case is Tanner versus Carmichael. Each part like 15 minutes of argument. Counsel, as you can see, there's no one to rebut, so give us that 15 minutes and no time for rebuttal during that time. We heard earlier the arguments are being recorded. Please make sure when you start to introduce yourself and tell us who you're representing. Make sure you stay behind the podium so we can both hear you and you can be visually recorded at that point. In this case, of course, being a parenting matter, we do have children, so please don't use any name for the child. Please use some initial or anything of that effect will be appropriate, or designations of your child. We read your brief and ready to proceed whenever you want.
May it please the court, my name is Paul Carriage and I represent the appellant Ebony Carmichael. As you may realise, I have quite an accent. If you have any trouble understanding me, don't be shy about telling me to repeat myself. It's fine, it's happened before.
I really like it, so.
Well, thank you very much. This is, yeah, very. This is my first time arguing in the 9th, and thank you for having me because this gives me a full set. I now have every Ohio appellate district. So thanks for hearing me out on this. Obviously it's a little odd because we don't have another side, so no rebuttal. 3 topics I want to discuss today. The first is I just really briefly want to touch upon Appellate Rule 18 and the circumstances of not having an appellee brief. Second, I want to touch again briefly upon the trial court's decision to grant parenting time to a non-parent. I don't think we have to talk about that for very long because both Ohio law and the United States Supreme Court precedent on that under Troxel is clear that just can't happen in circumstances like this. And then I want to spend the bulk of my time discussing the factors under 3109.04F1 and go through those with you because I think the trial court made some factual errors. Even under an abuse of discretion standard, there wasn't clear, competent and convincing evidence, clear and competent evidence to reach those factual conclusions. And the second part of the analysis would be on the later factors. The trial court just made legal errors. So, Appellate Rule 18, like I said, I'm going to just talk about this for a few seconds. The court may accept the facts as proposed in the brief by the appellant, and as long as the brief quote reasonably appears to sustain the claims, that would be enough for reversal. Now, I'm guessing you're not going to look at me and tell me you're going to apply Appellate Rule 18, so pipe down and sit down and stop. So, with that said, I'm going to continue, but that would be the end of the equation if that's what you decided. So, the United States Supreme Court in the case Troxel said that parents have a due process right to lots of things, including visitation, guardianship, custody time, and there are 2 parts of that equation that the court should consider. One is whether the parent has been deemed to be unfit. Here there was a request that Ms. Carmichael was deemed unfit, and that request was denied. So that's not part of the equation. We don't have an unfit parent situation. And the second part of the equation is that special deference has to be given to parents when making parental decisions, including visitation. Now, we're going to talk about this more as we go on, but the visitation is given to Derryl Tanner, who's not the biological parent, adoptive parent, not on the birth certificate, was never married to Ms. Carmichael. So there's no parent role under Ohio law for Mr. Tanner. The second part of that is that Mr. Tanner has been convicted multiple times of assaulting Ms. Carmichael.
Let me just for clarification purposes,
yeah,
in regard to procedurally how this transpired, did Mr. Tanner, was he granted leave to join in the lawsuit to intervene, or how, because he's not really a party, right?
Right, well, so Mr. Tanner filed the original action.
Okay.
There were 3 children, 2 of which are Mr. Tanner's children, and a 3rd child that at the time he believed to be his child.
Sure, I remember that, right.
And then it was later determined through DNA evidence that Mr. Williams was the parent of one of the 3 children, the only child that we're here to talk about. The 2 other children are not part of the equation for today.
I remember that, I just couldn't remember how it all started. So if he, when he found out, or when the court found out, and the parties found out, that anybody objected, say he shouldn't be a party to the young lady?
So my understanding is that that was not, well, so yes and no, which is always a terrible answer to give you, I know, but here we go. The challenge was based on venue. So neither of the biological parents nor the child lived in Lorain County, but the trial court kept Mr. Tanner in and said, no, I have venue because of Mr. Tanner. So look, when we
filed, at some point in time, he filed a motion for custody of all 2 children.
Yes.
And he continued asserting that action even after it was determined the child in this case wasn't his child.
Yes.
So he continued prosecuting his request for custody.
Right, and the Ms. Carmichael challenged that based on venue, and that the venue arguments were rejected by the trial court. So there's a little bit of a complexity here because I'm sure you've read the trial court opinion. The trial court didn't make a secret of the fact that it wasn't particularly keen on Ms. Carmichael's, I'm going to say, lifestyle choices or something. I don't really, it's a little hard to identify exactly what the trial court had a problem with. It looks a lot like the trial court had a problem with the fact that Ms. Carmichael was in an on-again, off-again relationship with one person. The reality is that that relationship was on again, off again because she was suffering from battered woman syndrome.
The trial court seemed to make some findings that, and I think, I'm not familiar with the record on the trial court's findings, that your client indicated that she kind of misled each of Mr. Tanner and Mr. Williams that they were the father of the child at various times. So that seemed to be concerning to the court. I don't know so much as it was as to them, but the effect, of course, of the child, where you're telling the child, hey, you're not being honest with the child who the parent is, that creates a problem for the child.
Sure, so let me clear that up. At first, Ms. Carmichael believed that Mr. Tanner was the father of the child. She told Mr. Tanner that she was the father of the child, that he was the father of the child. She then kind of did some math, worked out Mr. Williams was the father of the child, told Mr. Williams he was the father of the child, and then just never corrected her statement to Mr. Tanner. Now, I will tell you, and it's not a secret, Ms. Carmichael's not, maybe would have thought a little differently if she could do that again. That said, the reason that happened was because she was back with Mr. Tanner, at least during several times during this child growing up, and that was all part of the circle of victim, the battered woman syndrome circle of victim abuse, injury, attrition, break up, get back together again. So that's what's going on. So really, you know, if I'm going to be completely blunt about it, what I'm going to tell you is, yeah, she didn't want to suffer another broken bone, so she didn't tell him the truth. Should that be something that, you know, in an ideal world would not happen? Sure. But is that something that the trial court can punish Ms. Carmichael for? And the answer is no.
Well, not punish. I mean, the court isn't punishing anyone. They're trying to make the determination of best interest and how that affected the child. So saying that a shared parenting plan and person A instead of person B is going to be the relevant parent for full purpose isn't punishing her. It's just making the decision they're required to make under the statute, in my view. So I think she wants to punish. She's not. The court is trying to do their best to make the correct determination here.
So I understand completely what you're saying. I think that's what, if someone's going to argue on the other side, I think that's what they would say too. But I don't think the trial court's findings, when you compare them to the record evidence, show that's not what was really happening. The trial court, let me sort of skip ahead here to...
Well, let me ask you before, and let me just one more question on this
Sure.
issue of Mr. Taylor.
Yeah, absolutely.
Before we go to the other issue. So I appreciate your constitutional statutory argument. You can't order visitation in the circumstance of Mr. Taylor. It seemed to me below, from reading the record, all I saw was Ms. Carmichael saying, of course, Mr. Tanner should have visitation. child known Mr. Tanner's father all child life, that would be the best thing for the child to do. So how are we to deal with the fact that you have the arguments you made, but it seemed like below she waived the argument, or she at least consented to him having visitation?
So Ms. Carmichael consented to visitation, which is completely different to what the trial court ordered, which is parenting time. Parenting and visitation are different.
Well,
So does Mr. Tanner now have medical decision-making authority? Because if he has parenting time, he does, and that's not. There's a big difference between parenting time and visitation. Visitation would be basically the parent would say, like, hey, here's a great aunt, I'd love for you to spend time with this aunt. Then something changes and the parent says, actually, that aunt's kind of gone off the rails, I'm not going to let you spend time with that person anymore. That's what visitation, and that's what Ms. Carmichael was really conveying was, yeah, sure, if this is going to be a positive relationship for my child, then I'm going to let my child spend time with that person. If it's going to be a negative relationship, I'm not going to let my child spend time with that person. And that's exactly what Troxel requires the court to do. So when we get to Mr. Tanner, the first thing, so let me just add this, and what the trial court ordered was that Ms. Carmichael was required to give up only her parenting time with the child. Mr. Williams did not have to facilitate visitation or parenting time or whatever was eventually ordered. And Ms. Carmichael lives in DC, so she has to come back from DC and basically live in Ohio during the summers so that Mr. Tanner can exercise whatever right the trial court gave him, which the trial court orders as parenting time, which means that she's now having to move. She moved away. One of the reasons she moved away is to be away from the person that was abusing her, and now she has to move back for extended periods of time.
Counsel, the only thing with that is, and I have not read the transcript yet, so we'll obviously have to read the transcript and see how this all matches, but my understanding, the trial court is saying that Mr. Tanner and Ms. Carmichael were aligned together going after, and there was manipulation, there was, all the stuff that was going on. She didn't find her credible, she was manipulative. She hid the child. They were taking pictures of the child nude.
I'm sorry. I'm
taking pictures of the child.
It was the previous one. Did you say hid or hit?
No, I said
hid.
Thank you.
Hid. Oh, I'm sorry. I didn't understand what you were saying. I apologize. Yes, hid the child, and taking pictures of the child. In a state of undress in order to show how malnourished or whatever the child was. So those were the type of things that the trial court seemed to be looking at in making this determination.
So let's talk about this manipulation conclusion by the trial court a little bit, because I don't think it's supported by competent, credible evidence. So there was a recording which was referenced, a telephone call that was recorded. The trial court wouldn't allow that to be admitted as evidence, but did allow testimony. And Mr. Williams threatened Ms. Carmichael. There was a little bit of a dispute about whether he said, "You're lucky to be breathing" or "You're lucky to be alive." The trial court wouldn't allow that evidence, and based on that recording, Ms. Carmichael applied for and got a protective order from the Washington DC court, which the trial court in this case said, "I'm going to discount this protective order. I'm going to ignore it like it didn't happen because I don't credit it at all," and decided that Ms. Carmichael had manipulated the DC court into issuing a protective order and had manipulated the DC court into issuing it for a certain length of time without a hearing. I'm pretty sure that Ms. Carmichael has zero control over the rules of procedure in DC. That's not manipulation. That's if you get a threat by phone call and you take it seriously, you think that's a real threat, you go and get a protective order. That's what you do. That's not manipulating a court system. Apparently, there's a medical professional who, in the record, said this child is being neglected while being in the care of the father. Now, at the time, not actually sure which person we're referring to, but that's not. How is that manipulated? There's a medical professional who's made a decision. What if Ms. Carmichael is going to convince that person to just abandon their oath to to care for people. Ms. Carmichael was accused of manipulating the DC school. 100% of the evidence in the record is that the school was asked for records by the GAL. The GAL didn't provide a single document to convince the court that the GAL was entitled to those records. And Ms. Carmichael emailed the school and said, I can give you permission, what do I need to sign? That was Ms. Carmichael's sole role. On the record, the trial court called the DC school, and the DC school said, put her on hold for an extended period of time, and the trial court gave up. There's no evidence that Ms. Carmichael manipulated the school.
And just we're down about a minute of your time. We asked a lot of questions, but you have about a minute of time left.
Oh, goodness. Okay, so I'm not really going to get much of a chance to go through the factors here. So I'm going to skip ahead to the legal errors. The factual errors I think we talked about probably enough, and you can probably connect those dots anyway from what I've said in the brief. But the trial court said no one failed to pay child support. That's false. The statute requires an analysis of people that failed to pay child support, not just people that failed to pay child support in this case. That's a legal error. This court doesn't reweigh the factors. Because there's a legal error, that factor counts differently. You have to reverse and send it back. Because there was a legal error, which is de novo review of interpretation of the statute. Same thing with the trial court finding that charges on which Ms. Carmichael was not found guilty are more important, even though charges are part of the statute, convictions are part of the statute. But Mr. Tanner was convicted of child endangerment for abusing Ms. Carmichael in front of the children. And that didn't make its way into the trial court's decision, because the trial court found a charge on which Ms. Carmichael was found not guilty to be more important than a charge on which Mr. Tanner was found guilty of child endangerment. Mr. Williams has a conviction for felony conviction for not paying child support, and I'm talking fast, I'm trying to get it out in 1 minute.
I know, and your time is up. I appreciate that. You can briefly conclude.
Thank you so very much. Mr. Williams has the protective order and a conviction for felony failure to pay child support. Those both support the conclusion that there's a child neglect issue with the fathers. And then...
thank you, counsel.
All right, okay.
Your time is up.
Yes, I was trying to squeeze out one.
I understand. And we read your brief, and I think the
Yeah.
point you're making certainly are there as well, so, and they were duly noted at that time.
Thank you so
On
much.
behalf of the court, I'd like to thank you for your presentation today. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of the decision to you on the day it's released, and the opinion will also be mailed with the High Supreme Court website. With that, the court is now adjourned.